There is an image I cannot stop seeing. It has nothing to do with a courtroom. It is a woman sitting in a hospital cafeteria about 8 months after this case ended, eating a sandwich with her daughter at a corner table by the window. Her daughter had been told she would not be alive to eat sandwiches and watch television again. They were laughing about something small when someone who knew them both walked past. That image is why I am still talking about this case. Let me go back to the beginning. Her name was Patricia Okafor. She was 43 years old. On September 14, 2022, her heart entered a crisis that her doctors had been carefully managing for 6 years. What happened that afternoon required her to be moved by air to Mercy Regional Medical Center in Harlan County within a window of approximately 18 minutes. That is the word that stayed with me for weeks. Window. 18 minutes is about the length of a decent cup of coffee. It is enough time to save a life if the helicopter can land. The helicopter could not land. I want to ask you something before I keep going. Have you ever been in a room where the stakes were completely clear to everyone present and someone still chose to make it about themselves? Subscribe. Because that choice, and the way the law responded to it, is what I need you to stay for. State Representative Gerald Marsh had scheduled a press conference on the hospital grounds at 2:30 that afternoon, not in the parking lot, not inside the building, on the landing pad. His staff had erected a podium, a microphone, chairs for local press, and a printed banner that read, "Fighting for Your Health Care." The press conference was about a healthcare funding bill he was championing. His communications director confirmed in testimony that the helipad was chosen specifically for its visual impact. It looked right on camera. Patricia Okafor's helicopter pilot, Marcus Webb, circled the pad for 4 minutes and 22 seconds. He radioed the hospital. The hospital radioed Marsh's staff. The staff radioed someone. In those 4 minutes and 22 seconds, while the banner moved slightly in the helicopter's downwash, while Gerald Marsh spoke into microphones about fighting for people's health care, Patricia Okafor's window closed by more than a quarter. She survived. I want you to know that now because you need to know it to understand both rivers. She survived, but her cardiologist, Dr. Angela Torres, testified that the delay contributed to permanent cardiac damage that altered the rest of Patricia's functional life. She would not return to the work she had done for 19 years. She would need daily medication and monthly monitoring for the remainder of her life. The word survived is real. It is also incomplete. Gerald Marsh was 51 years old, 9 years in the state legislature. By most accounts, he was not a villain. And that is the thing I kept turning over in the weeks before this case came to hearing. He was a person who had moved through a sequence of decisions with such complete attention to one thing that everything else had ceased to exist for him. Nobody on his staff checked with hospital operations. Nobody asked what the pad was actually for. That absence of a question, that gap where asking should have been, was where the window broke. When he entered my courtroom, he was wearing a dark blue suit. Before the proceedings began, he looked at his own hands, not dramatically, briefly, the way a person looks at something that has recently done something they are still trying to understand. I had no way of knowing what that meant to him. I knew what it meant to me. Some part of him was still here, still present in a way that was not purely procedural. I noted it. I held it. I did not decide what to do with it yet. Patricia entered 8 minutes later. She walked carefully, the economy of someone for whom movement now requires calculation. She sat and put both hands flat on the table. Then she looked at the east window and just stayed there for a moment, not performing anything. She was not coming here to fall apart. She was coming here to be witnessed accurately by a room with the authority to respond to what had actually occurred. She knew what she was asking for, and she asked for it plainly. If you are still with me, you have probably gone quiet. Whatever was going on in the background has probably faded. Subscribe. That kind of attention deserves the rest of this story. Subscribe and turn on notifications. The case came to me as a civil proceeding with embedded administrative violation charges tied to unauthorized use of hospital emergency infrastructure. In plain language, Marsh's team had received written permission from a junior facilities coordinator who later testified he had not understood what he was authorizing. That permission did not extend to emergency designated zones. The helipad fell under Section 14.7 of the State Hospital Operations Code, which requires written approval from both the Chief Medical Officer and the Director of Emergency Operations, 2 signatures, neither of which was obtained. The junior coordinator's single signature was legally insufficient by a clear margin. When I first read the case file and understood that, I felt both things at exactly the same time: the weight of what that insufficient signature had cost, and a kind of clarity about the fact that the law had not failed here. It had been ignored by people who had not bothered to read it. Those are very different things. That distinction, felt in both directions simultaneously, was the first moment in this case that both rivers moved through me at once. Here is what I am offering, the rest of this story told the same way I have been telling it, nothing softened, nothing resolved before it should be, nothing withheld. Subscribe if that is what you want. I will keep going. The sorrow current began with 17 pages. Dr. Torres's medical timeline, prepared in clinical language that I asked her to translate during testimony into plain English. She described precisely what happened to Patricia's heart during those 15 minutes and 42 seconds. The circling, the delay, the rerouting. I will not recount it in detail. I will say only this. There was a list of things Patricia Okafor could do before September 14, 2022, and a list of things she could do after. The distance between those 2 lists was the weight this case carried from its beginning. Dr. Torres said from the witness stand, the delay did not cause her death. It changed the terms of her life. I wrote that down. That sentence belonged entirely to the sorrow current. It carried no comfort. It did not try to. The grace current began with a letter. It arrived with the case file, submitted as character documentation, standard practice, but this letter was not standard. It was written by a woman named Rosa Villarreal, a constituent of Marsh's district. Her son had been denied a disability accommodation at his school 3 years earlier, and Marsh had personally intervened repeatedly over 4 months until it was resolved. No press release, no political benefit. Rosa Villarreal wrote, "He did not have to do any of it. There was nothing in it for him. He just kept showing up." I read that letter at 7 in the morning before the first hearing day. I sat with it next to Dr. Torres's 17 pages. I did not know what to do with both things being true at the same time. I just let them be. The convergence happened on the 3rd day. During Marcus Webb's testimony, he was not a dramatic witness. He described the 4 minutes and 22 seconds with the precision of someone who had replayed them many times in his own head. He described circling the pad, seeing the press below, the banner, the podium. And then he said, "I have seen pads blocked before. Equipment, construction, nobody usually means anything by it. I needed that particular pad on that particular afternoon and I couldn't have it." He said it without anger, like a man who had arrived at a fact. I wrote it down. That sentence was the first moment in the entire proceeding where both rivers arrived in the same instant. The complete absence of malice in how the harm was done and the complete reality of the harm itself. Both things. One sentence. I did not expect that. In the back row during Webb's testimony, a man I later identified as a member of Marsh's volunteer staff sat with his hands loosely pressed together in his lap, not praying, not performing, just sitting in the specific stillness of someone who had understood something fully for the first time. That came from the confluence, not pure sorrow, not pure grace, just understanding, arriving late. I just realized, saying that out loud, that I had never described that man to anyone before today. Subscribe, because what I'm about to tell you about the defendant's own words on the stand is the moment this case fully became what it was. Subscribe now. Daniel Forrest argued that his client had obtained what he believed was valid authorization, that the failure was systemic, and that Marsh could not be held responsible for a procedural gap he had no knowledge of. He also said something that surprised me, not as a legal argument, but as a human addendum, that Gerald Marsh had not slept a full night since September 14th, documented by his physician. I wrote that down. It belonged to the grace current. It did not resolve anything in the sorrow current. But it was true, and it meant something about who was sitting across from me. What the defense could not resolve, and then I say this with honesty, not contempt, was the distance between the two lists. Argument, however skilled, cannot close a distance that is measured in a person's remaining life. And then Gerald Marsh testified. I asked him directly, "What were you thinking when you chose that location?" He looked at me, not at his attorney, not at the table, at me, and said, "I was thinking about how it would look. I was not thinking about what it was for." I wrote it down. I looked at it for a long time. Both things I was feeling were in that one sentence. I did not expect that. There is a memory I have carried since I was 27. A neighbor named Howard had a stroke in the hallway outside his apartment. I sat on the floor with him and held his hand while we waited 11 minutes for the ambulance. He lived 4 more years. He lost the fine motor function in his left hand, which mattered because he had spent 40 years repairing small mechanical things as a form of peace. He could not do it anymore. He was still Howard. He was Howard with something missing that could not be given back. I never thought about Howard in a courtroom before this case. I thought about him every single day of this one. I want to stop here for a moment, not for effect, because what I just said about Howard is something I have never said in any professional context before today, and I need a second with it. Subscribe while I take that second. Subscribe and stay. Okay, let me keep going. The room before I spoke was the way rooms get when everyone has been carrying something heavy and they know the carrying is about to change shape. Gerald Marsh sat very still. Patricia Okafor had both hands flat on the table. My hands were folded in front of me. I had decided carefully. I had decided knowing this ruling had to hold the weight of what was lost and also leave room for what might still happen. Those two things do not always fit in the same ruling. In this case, they did. I had made sure they did. I am ordering you to pay restitution of $475,000 directed in full to Patricia Okafor. This number was calculated from her actual medical records, projected lifetime care costs, and documented professional income loss. It is not symbolic. It is what the distance between the two lists costs in real terms over a real life. Money does not close that distance. It acknowledges it. Acknowledgement is where accountability begins. I am also ordering 300 hours of community service at Mercy Regional Medical Center, specifically in the Emergency Operations and Transport Coordination Departments, under the supervision of the Chief Medical Officer. Not general hours. Hours spent in direct proximity to the work the helipad exists to support, watching the clock that runs in that room every single day. I want Gerald Marsh to know what Marcus Webb knows. And there is one more thing. I am ordering a 12-week certified course in institutional accountability and public infrastructure ethics administered through the State Bar's Continuing Education Division. At the end of it, Gerald Marsh will submit to this court a written first-person account of what he learned from this case, not a press release, not a communication crafted for optics, a plain account, in his own words, entered into the public record. It is due 9 months from today. One condition for early completion. If Gerald Marsh meets with Patricia Okafor in a facilitated restorative session with a trained mediator on her terms at a time and location she chooses, the community service requirement reduces by 100 hours. I am not ordering Patricia to do anything. She has already given enough. I am offering Gerald Marsh a door. Gerald Marsh. What you did on September 14th, 2022, cost a woman the life she had built, not her whole life, but a real and specific part of it. 19 years of work, physical ease, the freedom of waking up without a protocol to follow. I want to say that plainly to everyone who came here carrying what happened. What was lost is real, it is documented, and this court sees it fully. To you, Gerald Marsh, the letter from Rosa Villarreal is also in this record. The 4 months you spent on her son's case when nothing required you to is also true. You are a person who has shown up when it was hard and when there was nothing in it for you. That person and the person who booked a helipad without asking what it was for are the same person. You will have to hold both of those things. So will I. So will this room. One fact, for no one in particular, a helicopter pad is not a backdrop. It is a door. Block it at the wrong moment and you change a life on the other side. You just heard what I said to him in that courtroom. I want you to hold that last sentence, the one about the door. Subscribe before we go further, because what happened after I said it is what I have thought about the most. Subscribe now. After I finished speaking, the room moved the way rooms do when a verdict has been received, and people do not yet know what to do with their bodies. I stayed seated. Patricia did not stand immediately. She sat with both hands still flat on the table, looked at the east window again, the same window she had looked at when she first came in, and then leaned to her sister and said quietly, 2 words I was positioned to hear. Okay, good. Not triumph, not simple relief. The specific tone of someone who has had a very heavy thing acknowledged by a room with authority and who is deciding right now to stand up and take the next step. Before I stood, I picked up my pen. I uncapped it and capped it again. That was all. I do not entirely know why. I know it came from the place where both rivers were running. On May 3rd, 2023, 7.5 months after the ruling, I received word that Gerald Marsh had completed his first 60 community service hours at Mercy Regional. His supervisor, Diane Cho, 11 years coordinating medical helicopter logistics, submitted a brief note in the monitoring documentation. She wrote, "He asked good questions. He stayed late twice when he didn't have to." The sorrow of what those hours were paying for was still present in that sentence. The grace of the fact that he was showing up for them was also present. I read it twice. I put it in the file. The ruling was appealed to the state appellate court on jurisdictional grounds. The court upheld the combined proceeding in a 3-2 decision issued 11 months after my ruling. When I received the notification, I was in the middle of a different case entirely. I set it down. My honest response, I was glad and I was tired, and both of those feelings were accurate and neither of them was performed. This case showed me something I am still working out. I have always, without knowing it, been choosing one current as the primary one and managing the other alongside it. This case would not let me do that. The sorrow was too real to manage. The grace was too real to dismiss. What I learned, what I am still learning, is that a ruling built from both currents is not a weaker ruling. It accounts for more of what is actually in the room. I have never said that in any professional context before. This case gave me the language for it. To the people who recognize themselves in Patricia's experience, who know what it is to have a window closed, to have something permanent taken from the ordinary life you had built. I watched Patricia Okafor over the course of this proceeding. I watched what happened to her as she was seen accurately, as her full loss was named plainly by a process she had trusted to do exactly that. Her loss was still there at the end, but something in the way she carried it changed. She was still carrying it. She was carrying it more uprightly. I do not have a cleaner word for what I saw. I do not need one. To the people who recognize themselves in Gerald Marsh's position, who caused real harm through carelessness rather than cruelty, and who are now living in the space between what they did and who they know they can also be, the people I watched move towards something were not the ones who felt the least. They were the ones who let themselves feel it fully and did not use that feeling as a reason to stop moving. They kept facing what they had done and kept asking what they could still repair. The door Gerald Marsh was offered in that courtroom is not unique to him. It is available in almost every situation where real harm was done without intent. The question is whether you will walk through it and whether you will walk through it for the right reason. Subscribe, that is all. There is a woman in a hospital cafeteria eating a sandwich at a corner table by the east window. Her daughter is sitting across from her. They are laughing about something small. That is why I told you this story. Leave what this made you feel in the comments. Not your verdict on Gerald Marsh, what it made you feel. This is the kind of space where people willing to hold two things at once tend to find each other.